All right. Well, hello, landlords. It's Ernie Garcia, landlord attorney, and today we're talking all about transferring property after death. As you may or may not know, we all die. And so when we own property, if we have not made arrangements for that property, that property kind of stays in limbo for a period of time. And unless you have made those arrangements, you kind of shift that burden onto your heirs, which is usually your family. And so instead of making the transfer of your property a burden to your family, we suggest setting plans in place that kind of relieve that burden and make things a little easier for your family once you're gone. And so for today, what I want to talk about is those situations where maybe you have a loved one who didn't take those steps, and now you're unsure how to transfer property. We get this all the time from clients who say, well, dad died in 1998 and mom died 4 years later, but the property is still in mom and dad's names. What can we do? Well, there are steps that we can take, and I want to talk a little bit about what's available in the state of Texas, which is similar to what's available across the country, but particularly in Texas, what's available to transfer property, whether it's been 1 year or whether it's been 30 years, what can be done in these situations to transfer property where there is no will and there has been no probate. If you've got a question for me, please send that. I'm happy to review those questions, and I'll do my best to answer those questions. I got James here asking a quick one about a TAA lease. James, the Texas Association or the Texas Apartment Association lease is a great lease, but usually if you're using it for a multifamily, if you're using it for a single family home, it has certain limitations because the anticipation of a Texas Apartment Association lease is that it's a multifamily unit. And so some things are going to be left off that you really should include in a single family home environment. But if you're using it for a multifamily, it's a great lease. If you don't have a lease, we write a pretty good lease ourselves. But what I don't recommend is you going out and finding some lease just out in the ether. Certainly don't just Google rental lease agreement. You get yourself in a lot of trouble because you want to make sure that it is set for use in your state. But questions just like that, I want to answer them, particularly on the topic that we're talking about, having to do with transferring property. So thanks so much, James, for submitting that question. Anybody else? Hi, Olga. Anybody else who wants to chime in and ask their questions, I'm going to save answering those questions until the very end. But yes, I'm glad to see that people are climbing aboard and on the live, and I look forward to getting into today's topic. So we're transferring property after a loved one has passed away. The first thing to consider is the proximity of that loved one to the beneficiaries, the people who are now taking title and ownership of that property. And often it's the case where we're not talking about a rental property necessarily. We're talking about the family home, and the home is being passed to a family member. And so one semi-easy procedure involves that. Mom or dad have passed away, and the recipient is that surviving spouse. And so they pass away, and certain very limited requirements come, and you don't actually in Texas need a full-fledged probate. It's a condensed procedure and the filing of what's called a small estates affidavit. But there are certain restrictions that come with this that I'm going to read off. And remember that the small estates affidavit does require some court. It's not the full probate. It's a scaled down version, so it's a little less scary, but there are some limits. So definitely the decedent had to have died without a will. No will, you can maybe do a small estates affidavit. They left no more than $75,000 of property behind, not including the home, $75,000 worth of property to be distributed or less. The assets are worth more than the debts. And so if there's a lot of debts and there's creditors out there who may come after this property, you're not going to be able to go forward with a small estates affidavit. The only real property owned by the decedent was their homestead. This is key. It can't be a rent house. It can't be that, grandpa left 3 properties. That's not going to qualify for a small estates affidavit. The homestead property will be inherited only by the decedent's surviving spouse or minor child or children who will be homesteading with the decedent, or who were homesteading with the decedent at the time they died. In other words, if dad dies, mom gets the house. If for whatever reason that wasn't already established somehow in the law, mom's going to take dad's share if they were each co-owners of the property, and it makes the transfer simple, or at least easier than you might have to go through an administration or through a probate, when, again, all of these requirements apply, or it goes down to the children. If both mom and dad are gone, but these minor children were living in the house with mom or dad at the time, they become title holders of the property. Now, sometimes you got to get into guardianship and other complicated issues when you've got minors who all of a sudden own property, but this is that procedure. So they won't be tossed out or they won't be disinherited from what belongs to them. This process takes care of that. So all the heirs are going to sign the affidavit, or there's a guardian in place they'll sign on behalf of a minor child. There has to be no pending application for appointment of a personal representative. In other words, there can't already be some kind of proceeding in the court, and then no administration is needed. There are certain times when there are complications of the estate, particularly when there are debts involved, and so a small estate affidavit isn't even on the table. But man, just talking about these complications, it makes people nervous. Like, they don't want the court. So are there, Ernie, any non-court options? And I guarantee you that there are. And so I want to talk about those non-court options, because these are easier ways to take care of things without having to go through all of these steps. Now, of course, whenever there's a contest and whenever somebody says, and James, you're very welcome. Whenever there is a contest, naturally somebody could drag something into court, especially if they feel like they should have gotten something that they didn't get because of these operations. So first, I want to talk about the affidavit of heirship. So an affidavit of heirship transfers property from someone who's passed away without a will and whose estate cannot be probated because it's been more than 4 years. And, again, dad died in 1998. And so an affidavit of heirship can be filled out and filed to establish who dad's heirs are. Now, sometimes dad's heir is mom. And so, what happens if mom and dad died without a will and they left 4 kids? Well, sometimes you need an affidavit to transfer all of dad's share to mom, and then everything that mom owed to the kids. So that would require 2 affidavits. But what is this? Well, an affidavit of heirship is a document signed by what's called a disinterested witness. And what they do is they say, look, I knew such and such. I knew who he was, and I knew who his heirs were. I knew who he was married to. I also knew that he didn't have a will. And so I can swear that I knew these things, and I knew that he owned this property, and that the following people are his heirs. In other words, they're his children by operation of this marriage, and there are no other heirs that are out there. And so this person, usually a family friend, and it has to be a disinterested person. And by disinterested, I don't mean somebody who doesn't care about the situation. I mean someone who does not have a financial stake in this inheritance, right? It can't be one of the persons who's subject to receive something because I don't look good. And so you always want a disinterested witness, somebody who knew that member of the family and can swear to these facts. We always like getting at least 2 individuals who can swear to these. So let's say you had a family friend who knew both mom and dad, who's still living and can testify to these facts. And they say, hey, we want, we are able to sign this affidavit. They fill out the affidavit testifying to the facts. And that affidavit then states unequivocally from dad to mom, and then from mom to the 4 kids. And this is a valid transfer of title. It can be recorded in the county clerk's office, where deeds and titles are recorded, deeds of trust, liens. So in your county or in your jurisdiction, wherever you record these deeds, you can record in Texas the affidavit of heirship to establish a written record of the transfer from dad to mom, mom to kids, or whatever distribution happens to be in your situation. But that affidavit of heirship prevents you from having to go and file a lawsuit, to go and get some kind of determination from a court, again, when the opportunity to probate the estate has long since passed. Now, you may find that a subsequent buyer is not going to be comfortable with this situation. Well, it's one of those things where, it wasn't signed by the actual person, so they put it into question. Maybe they don't want to deal with it. But in many cases, and you should check with your title company if you are in the middle of a sale, in many cases, a title company will sign off a title policy when they see these steps have been taken, because this is legal in the state of Texas. Wherever you are, there may be a similar procedure, but if you have not, or you're not in a situation where mom and dad left a will, you can potentially transfer property in this way, and now you are the owner by virtue of this affidavit. Now, there's one other way where you do get the signature of mom or dad or whatever family member is out there that wants to transfer title after they die, and they don't need a will to do it. This is called a transfer on death deed. And what a transfer on death deed says is, upon my death, I want this property to transfer to this individual. And so all that individual has to do is, once that transfer on death deed is filed, it has to be filed while the person is still alive. Once that's filed and that individual dies, assuming that the transfer on death deed has not been revoked or in any way amended, then simply an affidavit showing the death facts and recording those death facts transfers that title automatically to that beneficiary. So, for example, if my grandpa says, upon my death, I want Ernie to have property A, and I want Ernie's sister to have property B, then those two transfers on death deed. So property A, I'll go and file. My sister files property B. Upon grandpa's death, we both submit affidavits to the same property clerk, and voila, we are now instantaneously the owners. And this is something that's stronger than the affidavit of heirship because it was signed by the actual owner upon their death, and upon my submitting an affidavit establishing the death facts, usually with a copy of the death certificate, it's very easy for me to establish that I am now that owner. Now, can grandpa at some time withdraw? I talked about that a little bit. Yes. So during grandpa's lifetime, he can amend it or withdraw it. He can sell the property because it doesn't become effective until he is dead. So just like a will can be altered at any time, one's transfer on death deed can be amended during the lifetime of the individual. And so if you're in a situation where, grandpa does not have a will but does own property, and grandpa is interested in distributing it, there are certain tax implications of distributing it inter vivos. In other words, while he's alive. And I'm not going to get into all the tax implications, but it is far better from a tax perspective to receive that as an inheritance than it is to receive it as a gift during grandpa's lifetime. So we certainly don't recommend generally that families distribute property in this way. Instead, we would recommend various other things, among them a transfer on death deed as a better alternative to simply transferring it while they are still alive when we consider these tax implications. So if you have any questions regarding the transfer of property, again, whether it's setting up for it during one's lifetime or If it's dealing with it after a loved one has passed away, we strongly recommend that you seek out legal counsel in your jurisdiction. If you are anywhere in the state of Texas and want to discuss these things with us, you're welcome to send me an email at info@attorneyeg.com or give us a call. My contact information is all over my YouTube page, 832-305-7694. And so I got another comment from James here. He says, my parents set up a trust to transfer ownership of real estate. I was lucky to have on-the-ball parents. Yeah, and again, this is one of those times where, because there are a number of ways to transfer property during one's lifetime. Of course, today we're talking about how to do it after the person has passed away. And the transfer on death deed is that kind of before and after scenario, because grandpa has to do something before, but the transfer doesn't even take place until grandpa has passed away. So just the same, we'll eventually talk a little bit in the future about other ways to transfer property. In fact, next week, our topic is hidden fees, the costs of death on the remaining family member. So, we're talking about, we're going to run a series on property transfers and the implications of, setting things up for your property that really help you out. And a trust is one of those ways where certain fees can be avoided. But good estate planning is, essential, particularly as you own more and more property. So at this time, I want to go ahead and get into our questions. Let's see. Here we got a few questions lined up. Here's the first one. Almost any kind of requirement by a landlord or a fee or expense for an ESA is not allowed. I don't know about almost, but let's continue. Are we allowed to require that ESA dogs and cats be spayed or neutered? Intact animals cause more damage and can be more aggressive. If our municipality has a spay-neuter requirement, I assume I could, as the lease requires tenants to follow local laws. But being in a small town, we have no such requirement in the city code. Thank you. Okay, so remember that the federal law requires that you make a reasonable accommodation for the party seeking, in this case, an emotional support animal. And so is it reasonable, if you did have this law in place, to allow them to defy the law? No, it is not. So the reasonable accommodation would be, yes, you may have this animal, but because the local ordinance requires that they be spayed or neutered, I will not allow the animal on the property unless it meets that requirement. And so now you're asking, well, can I impose that restriction? And the answer is probably not. And so it would be different if this was a pet, but because it is a medical device as an emotional support animal, I don't believe you can make them do anything that will cost additional money in order for them to have their medical device with them. So unfortunately, if the local ordinance doesn't automatically require it, you can't have that as an impediment to them having an ESA with them on the property. Again, you really can't impose any costs or any additional restrictions that would otherwise prevent them from having this animal with them. Again, it has to be a reasonable accommodation. And so I think you would be unreasonable in requiring that additional step in this particular situation. So, all right, I got a two-part question next. Would you help clarify wills, probate, ladybird deeds, transfer on death deeds, heirship affidavit, and gifting of property? When and who really needs them? Wow, that is one power-packed question. And the short answer is not in this video or not, in this Q&A, because there's so much there. But my goal over the next few weeks is to deliver some helpful information on each of these topics over, again, the next few weeks. So today we talked about transfer on death and heirship affidavits. In terms of gifting property, again, I'm not a tax attorney and I don't know the tax code as it pertains to your local jurisdiction. But what I do know are basic elements of this transfer. And so when it comes to gifting, I'll talk a little bit about it. So first, if you transfer a property to someone right now, and I'm going to give just simple round numbers to kind of help illustrate these points. But if you transfer property to someone and say when grandpa bought the house, it was worth $50,000. So he bought the house for $50,000. And now in 2025, that same house is now worth $400,000. So that it's grown in value by $360,000. And let's say grandpa deeds it to you right now, and grandpa later in this year passes away, and you decide you want to sell the house. Well, you're going to pay a capital gain. So you're subject to capital gains taxes on that difference, the $360,000 in this case, or whatever it happens to be when you finally do sell, because you were gifted the property, you didn't pay anything for it. But if grandpa instead had left you a transfer on death deed, same year, you now take ownership upon his passing, and the house, again, still has that $400,000 present value, you actually get what's called a step up in your basis calculation, which means now if you sold it for $400,000, you would have zero capital gain. And so there would be no tax implication whatsoever. And you wouldn't have to worry about that because grandpa did it smarter by waiting and transferring in this way. You would have no capital gain. Now, what implications that has in your jurisdiction, I'm not going to get into. I'm not even a tax attorney, but I do know that transferring property in this way has that benefit definitely in the state of Texas. So let's go on to part 2 of that question. I have purchased properties, and when the deed owner has passed away with no will nor probate, the title company does an heirship affidavit, and that completes the closing. This has been so simple compared to the long process of wills and probate that I hear from others. This may be a longer than expected response, but I would really appreciate your response. Well, I mean, this is what this video is about. I think it also is an easy way after the fact if you can track down somebody who can sign that affidavit. Sometimes grandma and grandpa died in the 70s, and for whatever reason, title did not pass. Well, good luck finding someone who was alive back then who knew them well enough and is still cogent enough to sign an affidavit for you today. And the truth is, the longer you wait from the time of death, the harder it is to secure an affidavit of heirship because it's harder to testify to those facts. So yes, while it can be an easy way, it's not ideal. And so because of that, our preference is get stuff taken care of ahead of time to, yes, also avoid probate. In one way you can do that would be through the transfer on death deed. You skip out on probate, and there's no question as to the transfer because it comes directly from the owner to now the beneficiary. So yes, the affidavit of heirship is a solution. It's not the most ideal one, though. Okay, number 3. Thanks for covering this difficult but important topic. I would like to ask about leaving the property a trust so that those inheriting the property don't have to pay taxes until they sell the property. Does that exist? We're going to be talking all about trusts at a future date. But yes, you can transfer property in all sorts of ways to an entity. Trusts are a little bit different. And again, I'll get into more detail at that future time because I'm going to do a whole video on it. But you could transfer property into an LLC, even a corporation or a trust or a limited partnership. And, those entities have they go on for perpetuity. They live forever. An LLC will not die, even though we will. And so Garcia Properties LLC can and will outlive me and can own property and transfer property in the future. If a new owner, or in the event of a trust, a new beneficiary steps in, so management of that property can change over time while the ownership remains the same. So if my LLC owns property and I own that LLC, say with my spouse, and then I pass away, and then later my spouse adds, say, a child onto that LLC as another member, and then my spouse passes away, well, guess what? Ownership has never changed hands. It's always been in the LLC and will continue to be until there is some transfer by an authorized member of that LLC. And the authorized members can continue to change over time depending on who has that authority in accordance with the management agreement set up for that LLC. Just the same, a trust can establish certain beneficiaries based on a certain trustee for certain uses and certain purposes, all of which are lined up in that document that you as the original owner can set up in order to preserve ownership within a certain group of people or use of a property in a very specific way, and also potentially to avoid tax implications or in a lot of ways the effects of creditors from coming against that property, even though you want certain family members to benefit directly from that property. So, okay, let's see what else we got here. All right, we got, I use a TAA application and it asks marital status and citizenship status. I'm a little leery about asking that and want to make sure it's legal to ask those questions. Absolutely, it's legal to ask about marriage and citizenship, but you can't discriminate based on citizenship. You also shouldn't discriminate on the basis of sexual orientation, and whether that involves marriage or not isn't always at issue, but could be. And so, yeah, you can always ask, but that, again, you got to follow the law in general when it comes to that. And so I think that is the last question that we had on today's live. And so today we're coming from Houston, where, we've just experienced a snowstorm, which is an odd and very, new thing for a lot of us, very unexpected. But here we are dealing with it. The truth is, the unexpected happens all the time. That was actually the topic of a previous YouTube live. And, the transfer of property has to be on our radar. And if we own property, we can expect sometimes untimely events to occur. And so the better prepared we are for these, the better off our loved ones will be when we pass. Again, if you haven't thought about, how your property is going to be transferred in the future, I strongly recommend that you do that. If you need to talk to a legal professional to assist you with that, get that done sooner rather than later. I promise you, your family will appreciate it. James, you're welcome. You say, I need to set up a consultation with you since I have many questions. Discovered your channel recently and appreciate all your information. Well, that's very nice, James. I appreciate you too. I appreciate you contributing and asking questions. And yeah, you want to set up a consultation. I welcome that. Look forward to that. And to everybody else, it was a pleasure meeting with you this afternoon. I wish you the best of luck in everything you do. And until next time, landlords, happy leasing.